Good morning, ladies and gentlemen. The Joint Select Committee on Legal and Financial Affairs is now reconvening in public, and we are being broadcast live on the Parliament channel. So I will also like to welcome the viewers who are looking at their television sets and following this program. This is the first public hearing of this committee, and I think this is the first public hearing for this 11th Parliament of the Republic of Trinidad and Tobago. My name is Sophia Choate. I'm a member of the Senate. I'm an independent senator, and because of that fact, I happen to chair this particular committee. This is one of those committees which is required to be chaired by an independent senator. To my left and right are parliamentarians who will in a moment introduce themselves to you. But I ought to introduce you to the clerk to this committee, Mr. Julian Ogilvie, who sits to my left. And there is another gentleman who normally sits to his left, Mr. Siwnarine, who is a member of the Secretariat, which assists this committee. So I will ask members of this committee, please, and I will begin with Mrs. MacDonald, to introduce themselves to you.
Thank you, Madam Chair, and good morning to all. My name is Marlene MacDonald. I'm the Member of Parliament for Port of Spain South Constituency and the Minister of Housing and Urban Development.
Good morning, all. My name is Randall Mitchell. I am the Member of Parliament for San Fernando East, member of the House of Representatives, and I'm also the Minister of Public Administration.
Good morning, everyone. I'm Dean Stooge. I am an opposition senator.
Morning, Prakash Ramada, Member of Parliament for St. Augustine.
Good morning, Clarence Rambarat, Member of the Senate, Minister of Agriculture, Land and Fisheries.
Good morning, all. Michael Coppin. I am a government senator, and I am the vice chairman of this committee.
Now, we have two persons sitting before us today. One is the Inspector of Prisons, Mr. Daniel Can. Mr. Can, would you introduce yourself and the lady sitting next to you?
I'm Daniel Can, Inspector of Prisons. To my right is Ms. Manki Sukram, Attorney at Law, my legal advisor.
Yes. I also would like to welcome those members sitting in the public gallery who I understand are students of the Hugh Wooding Law School. Is that so, Mr. Can?
Yes, please, Madam Chair. The committee was kind enough to allow students of the law school and part of the criminal legal aid clinic to attend, and I'm grateful.
Yes, well, thank you, students, for attending and showing an interest in parliamentary procedure.
We have some legal aid.
Is there anyone here from the Legal Aid and Advisory Authority? Oh, Ms. Anu, of course. I'm sorry I missed you. Would you want to come and sit at the table next to Mr. Can?
I don't think so.
Chair, I also have with me Joan Elsie Gill.
Sure. Yes. Of course, I'm sure there are enough seats there. It don't matter, it don't matter. They feel nice that they're being called up to the front.
This is interesting. There may be someone from America meeting.
Right.
You just acknowledge.
Now, you probably want to know why I have asked these ladies to come and sit at this table, and it is because the Legal Aid and Advisory Authority is one of the stakeholders in the inquiry in which we are about to embark. So while the authority is here only to observe today, that is, unless they say otherwise, we would like members of the viewing public to understand that the Legal Aid and Advisory Authority is represented. They answered our call for assistance, and they are here to observe and will probably be making a presentation on another occasion. Now, I would like us, before we begin, to remind ourselves of the objectives of this inquiry. The Constitution permits, Section 66 of the Constitution in particular, permits parliamentary committees to conduct inquiries into a fairly wide range of matters. But our inquiry, or this inquiry upon which we have embarked, is a fairly specific one. We've highlighted 4 things that we will be looking at. 1, we want to gain an appreciation of the number of outstanding matters, both indictable and non-indictable, before the criminal courts. We want to understand the systemic reasons for the backlog of cases in the criminal courts. We want to understand the efforts being made and the challenges that exist in alleviating the backlog. And perhaps in our report at the end of the day to make recommendations for the improvement of the system of criminal justice. Now, I ought to make it clear that we wrote to various persons seeking to obtain information. For example, we wrote to the Commissioner of Prisons. Is there any representative apart from the inspector from the prison services here?
Madam Chair, I don't believe so, but if the committee could take note, there are 2 members for the responsibility of transporting prisoners, who I understand also made written representations present.
Yes, they are from Amalgamated Security Services Limited,
and they are
yes.
within the audience.
Good, thank you. And we had also written to the Registrar and Marshal of the Supreme Court and the Court Executive Administrator of the Supreme Court. Now, these officers are not here, and they have provided us with some legal material for our consideration, and we will address that on another occasion. But we want to move forward with the inquiry, not waste the day. So we are very grateful to Mr. Khan for his attendance and for placing himself in the hot seat, as it were. Now, is there anybody who would like to start off with questions for Mr. Khan? I take it we all have copies of the written material sent? What?
Madam Chair, if I may, I know I'm allowed to make an opening statement, and I'm wondering if I could probably get the ball rolling in regard to that, and perhaps inveigle some questions after my
Sure, I just thought that because you had sent us something in writing that you preferred for us to look at that, but of course.
Yes.
Go right ahead.
Madam Chair and Committee, if I may, delays are endemic in our criminal justice system, and generally, currently, the judiciary is being held accountable for these delays. Public confidence is low. The justice system is very, very backlogged. And often, while I have been Inspector of Prisons for about 5 years, there are often well-articulated policies seeking to alleviate the backlog and address the problems, there are always many recommendations of specialized courts, more judges, more judicial facilities. But the tenacity and the collaboration effort to have the committees, not referring to this committee, of course, to investigate into the criminal justice flow system is often more excitable to have the committees and make reports rather than to implement them. The drive to have the committees does not extend as far to the implementation of the recommendations. And we have, and I speak as a criminal defense attorney, slowly and surely seen the criminal justice system almost grind to a halt, with our current sitting Chief Justice referring to that in his opening speech in 2013. The effect on prison is that remand prisoners have a different psychology, a different view than inmates, convicted inmates. Convicted inmates have an idea of how long they will be there. Remand inmates, when they go to court, they have a hope that their matter will start and a hope that they will be successful or acquitted. And that is when they're transported there. When they're transported back, they're transported in despair. And it's the alternating feelings of hope and despair that cause them to be aggravated and depressed, which is a very light term to put it within prison. The remanded prisoners are more aggressive, more feisty than convicted inmates who are settled there and have access to facilities. And as set out in the letter under the hand of the Commissioner, it does highlight the practical difficulties, but there is a psychology and mental effect that remand prisoners are suffering, and this is a direct effect of the delay within the justice system. And if the committee, that is my opening statement, to understand the heat in the prison.
Thank you, Inspector. Mrs. Sturge, do you have?
Madam Chair.
Mr. Khan, you are both Inspector of Prisons and a practicing attorney, is that right?
Yes, member.
Now, with respect to the remanded prisoners, you can classify remanded prisoners as those who are awaiting trial and cannot access bail because of the law, murder for instance, and the various bail amendments, and the others would be those who are on bail but cannot access bail. Can you give us an idea in terms of the ratio between the two?
In terms of the ratio between different types of remandees, it would be difficult. If the committee, in terms of inmate population, it is perhaps, and I'm subject to correction, about 60% remandees as opposed to 40% convicted. And that is figures that I had 2 years ago, before the more strict bail laws. But I would be subject to correction, and I would make written clarification of that if allowed.
Now, I'm interested, quite apart from those who cannot access bail, particularly for murder, there are those who are on bail but cannot access bail. You would agree, if measures are put in place, we can reduce somewhat the prison population if we assist those persons who are on bail but cannot access bail?
Yes, and if I could answer that question in that the government's or legislation is often put to restrict bail, and I always understand that's the idea that it would solve crime. It often, and it does, infringe your presumption of innocence, and it is a balancing exercise. I'm always of the opinion that you ought to put some faith into the judicial officers and believe that they will exercise their discretion in a judicial way taking away their discretion to grant bail absolute causes problems. Further from the idea that there's no bail for murder and there is increasingly many murder accused. On the other issue of when you're entitled to bail but cannot access it, it rarely comes to the point where most of those charged with violent criminal offenses are often of lower socioeconomic means, and they do not have freehold land to access bail, unlike in the United States and other jurisdictions, where someone would stand your bail, and I refer to, they would undertake the responsibility of you bringing you to court and financially suffer if they don't. We do not have that system. So you have increasingly inmates, accused defendants that are allowed bail but cannot access it, which I hope addresses your question.
Yes, there was...
Mr. Sage,
I'm sorry.
can I just interject and ask a question? Mr. Khan, you said you had prepared a report and you were relying on statistics from 2 years ago.
Yes, please.
How often are you required to prepare an inspector of prisons report?
That would be yearly, please, Madam Chair. I am currently drafting this year's report, which I would have liked to put before the committee, but proper procedure is to submit it to my line minister first.
Yes, indeed. And that would contain all the current statistics.
Yes, please. Madam Chair, I was focusing on similar ideas currently. You often have the focus of prison to change from prison conditions then to another issue, and currently the issue is delays, which my report would assist on that issue.
Thank you. Yes.
Yes, Mr. Khan, you just raised an issue with respect to prisoners who are on bail but cannot access it, being in the lowest socio-economic bracket. Do you have any suggestions as to how we deal with such prisoners, since you raised the issue of they not being seized and possessed of an estate in fee simple or freehold land, owners of land?
Well, the first thing is to allow bail where you have a cash alternative, or there's electronic monitoring bill. I'm not sure where that's reached. That would allow, to satisfy your bail conditions, that could allow that without you being financially set back. Or you simply pull back the bail conditions, you pull back the bail laws.
Meaning what?
You revoke some of them.
Which ones?
The ones for the most minor offenses, the ones where the risk of the offender being in the larger society is less than the risk of him being within the prison system. You are putting more and more people in a volatile situation. You are exposing those who are charged with less serious offenses, such as possession of marijuana. There was a one inmate highlighted that stole some coconuts, and he was a socially displaced person, what we would call a vagrant, and there was no one to take his bail, and he was there for upwards of 9 months, and he really just, as countrymen do, helped himself to some coconuts. And that really is farcical and shows how strict laws can lead to abuse.
No.
Well, could I just ask, he had been in custody for that period of time. What was happening with his case? Do you know? Or does the prison have a record of the speed at which prisoners' matters are dealt with?
Madam Chair, they do. That information would be before the warrant section, which comes back with an endorsement from the judicial officer saying remanded in custody, perhaps a note saying file not ready. That specific example, while extreme, is someone in the county courts that may not have the benefit of legal advisors, and goes back and forth. But the statistics can help, but it's all the same solution to the same problem.
Thank you very much, Chair. I'm very interested, and actually I want to congratulate your expression in relation to bail. I will tell you now that work had been far advanced in relation to the cash deposit system, and I find it troubling it has not yet been instituted when I demitted office. Equally, in relation to electronic monitoring, equipment had already been procured, and that we were to have instituted that in the month of September. We're now in February. I'm hearing that there is no step to take that far. In relation to bail bond houses, we had also done a tremendous amount of work to the point of actually bringing it into reality. So now we are in the presence of ministers, and this is a very important committee. So I think it will be important for us now, having heard, and your opening statement was very, very important to me, when you said that this is a committee and the implementation of solutions is something that we faltered on. I want to assure you, knowing the members on government and the opposition, and indeed the chairman, we do not intend to let this be a paper committee, but that the recommendations are followed through and action taken to fix these things. So having now highlighted those issues, which I tell you I'm surprised that they have not moved forward, and the ministers present and chair, this is a matter that we need to pursue, because I tell you it was on the point of being delivered. That would dramatically improve your circumstances in the prisons.
Certainly. Mr. Rambarat, I believe you had a question.
Just to follow what Mr. Ramadan has said, and just to put things in focus, Mr. Khan. This committee is examining criminal case flow management in the judicial system. And my assessment is that the backlog in the flow of the cases in the system creates a problem in the prison. That's the first thing. Secondly, my assessment is that the prison may not be playing the role it should be playing in rehabilitation for a number of reasons. A complete role it should be playing. And third, my assessment would be that the prison conditions may be contributing to the wider issue of crime, and in particular, repeat offenders. And that is the context I feel we want to talk to you today. Now I know, because in my life as a columnist, I wrote on crime and prisons in particular. Between 1945 and 1980, there were 7 reports on prison. And those 7 reports contained about 1,000 recommendations. There were 3 recent reports, which together contained about 100 recommendations. 2002 task force report, which was 440 pages. Your 2012 report as Inspector of Prisons, 500 pages. And your report in 2012 was the first report by an Inspector of Prisons for 30 years. And in 2012, Selwyn Ryan's report, the report of his committee, 434 pages, that contained 15 specific recommendations for prison. So that the context is that this is a long-studied issue of prison conditions. It's a contributing factor to the crime in the society, as every report has identified. There are recommendations that have been made over and over and over, and I agree with you. Professor Ryan's report was titled "No Time to Quit," and our report should be in the context of "It's time to act." Thank you.
Mr. Khan, I would actually like to ask some questions of you. From my understanding, there's nothing in law which requires freehold property for bail. So in light of the fact you made mention of persons not having freehold property because they are at the lower end of the socio-economic scale, quite apart from us waiting on electronic monitoring and so on, do you believe that there should be a right to own bail for the most minor of summary matters,
Or alternatively, do you believe that decriminalizing certain offenses would relax or ease up, so to speak, the congestion in the prisons? And without being controversial, I wouldn't want to say possession of marijuana right away, but you agree, there are persons, we both attended there with Professor Diosaran some time ago. There were about 2 cells with what we can loosely call madmen. So they are there for certain minor offenses mainly, but they should not be in prison. That's not the best place for them. You agree that there were persons over the course of the last few years who died in prison, and when we find out why they were there, it was failure to pay maintenance and so on. And just this week, a prisoner, Wayne Clement, who was remanded sometime for fraud, also died. Now, in the context of jail being for the most violent offenders, do you agree that, or which do you think would be much more workable in terms of relaxing or reducing the congestion? Is it that we do away with many of the summary offenses like obscene language, resisting arrest, and so on, the more popular ones that come up every Monday morning in court and flood the courts? Or should there be some other alternative outside of the electronic monitoring, which we seem to be waiting on for a while?
Member, I agree with most of what you said, probably not of how you put it.
Okay, I'm a bit direct.
The madman could be someone suffering from mental health issues.
Yes.
We wouldn't want to refer to them as that. The lesser serious offenses, I generally am someone that does not believe in absolutes or mandatory provisions which do not show the faith in the judiciary. So it is unlikely that someone charged with an obscene language or the minor offenses will abscond, and it is more burden on the system to deny him bail than allow him bail and he absconds. If one was, say, 10 out of or 5 out of 100 people charged with minor offenses abscond, and the procedures to get them before the court, it's less onerous than keeping them in prison. Your 2 suggestions, the freehold issue, yes, by law, you don't need it. And what I think ought to be done is the judiciary give guidance to judicial officers on how to grant bail. So the discretion is there, but you have some guidance. The judiciary has, to much praise, given guidance on sentencing, which has gone a long way to have lack of discretion. You have some guidance and also other things. So guiding the judicial officers on bail would assist. I'm not sure if I have answered your question, though, Member.
Yes, you have, but what I want to know is, do you agree that you must agree that on Monday mornings in particular, you'll see so many persons coming before the courts for simple possession of marijuana, and they may be repeat offenders because they are habitual users, or on Monday mornings, the courts are filled with persons coming before the courts with obscene language, and once you use obscene language, it's resisting arrest, obstruction, and everything else on the statute books. Do you not agree that perhaps we can get some system where these persons do not need to appear before a court, perhaps a caution at the police station, written cautions or warnings, and if you rack up 3 or 4, only then you come before the court? Would you not agree that these are better options as opposed to the existing predicament with bail, accessing bail?
To your leading question, I would answer yes. It is in the United Kingdom where you can't give warning for lesser offenses, and I will take your word from it that happens on a Monday morning. I haven't attended magistrate court for about 2 years.
Yes.
Mr. Rambarat has a question.
I'm sorry.
Mr. Khan, going back to your report from 2012, and the work you've done since then, what are your views on the impact? Or I have a feeling, based on my interaction with constituents of Mayaro, some of whom are under your care, that meaningful access to justice in the form of legal aid presents a problem, particularly in rural communities. And a contributory factor to the backlog in the criminal justice system is access to legal aid, access on a timely basis, access on a consistent basis. So I would like to hear your views based on your report on the, whether this issue of access to legal aid is a contributory factor in the backlog.
Yes. Member and Madam Chair will answer that question, not really so much as the Inspector of Prisons, but more so as a member of the Legal Aid panel, and forgive me for saying the son of the DC, and familiar with the legal aid difficulties. The Legal Aid did submit submissions February 12, 2016, which did acknowledge the concern of member in that there are several what I call rural courts, and it is not as staffed as the main courts, and it does present difficulties, and I would have to agree.
I want you to answer as Inspector of Prisons.
Yes.
In other words, within the prison system, is there an issue of access to legal aid? In other words, for the prisoners and the persons on remand yard, is access to legal aid contributing to their ability to put forward their cases in the court? Is it contributing to a backlog?
Yes. And the difficulty is with the median to get the information to legal aid. If it were, and I'm subject to correction, that there's an attorney based or there's an open communication, this person has come from this is the charge, they wish legal aid, and in a timely manner, I'm not saying it's not made timely, to communicate and appoint for those rural areas. And I'm subject to correction whether there's someone, and I use the word loosely, staffed from legal aid, although I am aware that several legal aid officers will attend prison perhaps once a week to take requests for legal aid appointments.
Is this done for the prison Tobago as well?
I understand, yes.
Yes.
Madam Chair,
Yes.
question through you to Mr. Khan. My colleague, Mr. Rambarat, Senator Rambarat, made reference to Mayaro. But it's not only Mayaro. I want to tell you about the constituency I'm from, Port of Spain South and surrounding environs. And there are many horror stories I would have heard with respect to persons attempting to access legal aid. For my own personal edification this morning, what is the problem, or what you see as those obstacles in legal aid which would prevent access by those persons at remand yard who would like to access your services? What are the problems? I would like to leave here this morning with a sense, of satisfaction. I understand your problems, because when I understand your problem, I will take it to the relevant minister. As you said before, I think Mr. MP Prakash Ramadan said, it would be, this committee is a committee of implementation. So I would like to hear from you. Give me a sense of comfort this morning.
In regard to the prison and access to your constitutional right to an attorney, what ought to be put in place, and I understand it was be put in place, is that you're allowed to make a telephone call to communicate to your attorney, probably under supervised, and where you could check the number is what you are saying it is. Two, because the difficulty is, remember, if I could answer twofold. You have an attorney, but to communicate with him may be difficult. Because of the lack of staffing and visits, an attorney will spend an entire day to see a prisoner. And if the attorney, often a popular attorney, may have many clients, to sacrifice one day to see a legal aid attorney, no disrespect to legal aid and their funds, is very onerous on financially on you. So to allow a telephone call to communicate one with your attorney, yes. And I could say the legal aid also is understaffed. There are so many applicants for attorneys that in-house, which was your recommendation in the director's February 12th of this year's letter, is to have more in-house attorneys and perhaps raise the fees for the out-house attorneys, if I use that phrase.
Mr. Khan, is there any branch of the prison that perhaps could assist with this communication? Can the prison welfare branch, for example, facilitate prisoners in custody to communicate with their attorneys?
Yes, and it does happen where a welfare officer will call an attorney and communicate the concern of the inmate. However, the staffing or the under-resource, if you have 1,200 inmates wishing to reach 1,200 attorneys or 300 attorneys, it is a staffing issue. But, Madam Chair, if I could say the systems are there. The systems exist. The solutions exist. The policies exist. The how to solve the problem is simply, are we, and forgive me for saying we, are we going to invest in what we think would solve at least some of the problems? That is the only question.
Which brings me to the next question. That is to say, in your report, I'm sure that you made certain recommendations in 2012. Can you tell us whether any of those recommendations have been implemented?
Madam Chair, no, I will not be able to answer that question because I'm not really part of the implementation part. And if I could say, the 2012 report really dealt with matters of prison conditions, legislative framework. It didn't touch the bail and it didn't touch delays, which has developed in the last 2-3 years to be the current focus on the prison system. But I do hope that my 2016 report will touch some of that. And if I may be able to say, as member Mr. Sturd said, to decriminalize certain offenses, which the learned Chief Justice did say in the opening address in 2013, to ease up bail conditions, to have more non-custodial options, and probably it is to put some pressure on the DPP to start accepting some of these lesser offenses pleas or requests. And the Chief Justice did say and forget, Madam Chair, may I continue?
Certainly.
Yes. The Chief Justice did say, well, look, we cannot try all these matters. We cannot. And the last time I saw Ms. Sitahal, we attended a plea bargaining session. And it was the best solution to the indictable offenses backlog. It simply cannot have, and my mother would say, what we just need is some elbow grease. Everybody just get down and we do the work, we take the pleas, prison prepares the reports, legal aid appoints the people, the DPP prepares the files, the judiciary sentences, and that would address at least the indictable offenses backlog. Those to me are the solutions that I would include in the 2016 report. And
Yes.
the ones.
Well, I believe that there is in place now the MSI procedure, which was introduced, I think, by a practice direction by the Honorable Chief Justice, and I understand that some judges are making use of it.
Yes, before, but it still does not force the hand of the DPP to accept some of these lesser offenses, murder to manslaughter. They are a development away from murder. And remember, Mr. Ramadan is smiling, but Mr. Ramadan once made 8 years ago an application for bail in a murder case. I recall that, and I thought it was quite interesting. Not saying that's the solution, but you have to give something. You can't have it all. The judiciary cannot hold on to this idea that we are the guardian of justice, we are the savior of the nation. We are not doing, and forgive me for saying we all the time, we are not doing what we ought to do. And we are so delayed that what we're asked to do, we can't even do. So we have to pull back a bit and say, well, look, we're not here to solve crime. We aren't the savior of the nation. We have our principles of sentencing, which Member Rambarat did say is rehabilitation. And we are not achieving it. Deterrence simply doesn't work because detection rates are so low. Retributive or revenge doesn't work because you're taking the revenge 10 years later. Rehabilitative doesn't work because the prison conditions are poor. And if I may say, in regards of delay, Member Sturge had said, jail, there's a difference between jail and prison. Prison is for convicted people, and prison is well suited for convicted people. The convicted people are doing well. Jail is for remand people, and we in the prison system are asked to take care of remanders, and we don't have a jail. The responsibility of remandees are the judiciary, and they've asked us, the prison, to keep these inmates till their case starts. And we are suffering the problems of delays. Yes, you could blame the judiciary, and yes, when inmates come up. And Madam Chair, forgive me if I'm speaking too long, if I may continue.
Sure.
While prisoners may be loaded up in court and shout and all that for 5 minutes, and you appease them and you mama guide them, they still go back to prison, and prison where they live is where we work. And they are hostile. They are hopeful for their case to start. And the remandees are not philosophically our problem. They are not our responsibility. It is judiciary's responsibility, and yes.
We have a question from my Vice Chair.
Good morning, Mr. Khan. You began your presentation basically by speaking about the psychology or the psychological differences between prisoners and those on remand, and you just continued a bit a while ago. The Commission of Prisons, he also submitted some reports on comments on the situation, and he identified also those awaiting trial as being the most troublesome or the biggest problem for the prison system. So there seems to be a universal consensus as to the problems created by persons on remand yard. And one of the comments he made, or one of the reasons he believed for this problem was the lack of the inadequacies of the existing regulatory framework, the 1950 Revised Ordinance, Chapter 11. What recommendations, if any, would you make? Because he says it is veritably silent on the treatment of remanded inmates. What type of recommendations would you make with regards to the amendment of this regulatory framework?
Yes, the 1943 rules are advanced thinking in rehabilitation, but as you correctly said it, Vice Chair, it focuses on inmates. In South Africa, there's a specific separation between jail under the head of a completely different, if I call supervisor, than from prison. They are financed differently. I don't believe they were at one point under different ministries. There was a 2005 South African paper to recommend the separation, and then a 2012 or 13 paper to highlight how the separation has occurred. So I hope that answers your question. You have to philosophically separate the remandees and how we treat them, and former Chief Justice Sharma in 2003 talked about the cruel and unusual punishment to those who are presumed innocent, separate and apart from those who are convicted.
Just Following on that, has any scientific study been conducted? Because you said earlier that you found them to be more depressed and more aggressive. Is there any concrete statistic, maybe in your annual reports, which we can point to, which perhaps could commence the philosophical, understanding of the differences between these individuals?
None that I know of, but I'm sure with the World Wide Web it could be sourced. And it
as relates to Trinidad, but
no, none that I came across. But often when people like the commissioner or those within the system who have about 30 years day in and day experience, you talk about evidence-based observations, although one cannot do the survey in terms of what psychological deficiency you are suffering from. It simply goes, you go to this prison who has remand and you see a lot of people shouting. You go to MSP, you see some people playing football and everybody's cool and they're convicted. But I agree, sorry Mr. Tai, I agree that they ought to have some firm written confirmation of this.
Could I just ask you, do your responsibilities include YTC?
No. I sit on the Board of Management of YTC and I report to the commissioner who has control of YTC but no, I'm not in charge of YTC. I sit as the chairman of the Board of Management and we make recommendations to the commissioner who would then make recommendations to the line minister. If I could take
Well, could you just give us some statistics? I know earlier you said about 60% of the persons in prison, in our prisons, are persons on remand. Could you tell us what figure that 60% would be?
in terms of lads, Madam Chair, in terms of YTC?
No, in terms of adults
population.
in prison on remand.
Remand population.
The 60%, I did not include YTC. I always separate that. In my opinion, last time they're generally between 95 and 110 lads, as we refer to them from the English system, within YTC. Obviously, that has changed because of the Children's Act, but they generally do not cross 150.
Okay, and what about adults? How many adults are there on remand?
The inmate population overall tends to be around 4,000, up or down a bit. And Madam Chair, if I defer that question, because I don't want to misinterpret or misinform, but it tends to be more than half tend to be remandees.
Well, this is
which is 2,000, please.
About 2,000 persons on remand.
But I would not want to be...
On average, 2,000.
I would say so, yes. But that would be at best within the knowledge of the warrant section.
Mr. Khan, if I may, following on the question asked by the Vice Chairman, would you agree that the majority of the prison violence or the violence in the system comes from the remand section of the prison?
I think that question is best suited for the Commissioner, not that I don't want to answer, but I would say generally yes, and it turns back to what Vice Chair said. It is a psychological difference, and it is increasingly difficult where there's more so an issue of separation of the inmates.
Now, because these persons are not proven guilty and presumed innocent, I want to ask a question, several questions on this issue, with respect to murder in particular. Can you tell us, on average, between what's the waiting time between charge and committal, between committal and indictment, when you actually get a deed to go to court, and between receiving your indictment and first appearing in court and the final resolution of your matter in the High Court? That's the first thing, if you can tell us. And from my own understanding, correct me if I'm wrong, do you not agree that the longest waiting period from first charge to completion would be the time between committal for trial and indictment, that period where the DPP must file an indictment after committal?
I would not agree to your last part. If I could answer generally, between charge and filing of indictment, which is your first appearance in High Court, and if I could clarify the terms, for you are charged with an offense, an indictable offense. There has to be a DPP attorney appointed.
Right.
You then have your preliminary inquiry. The outcome of the preliminary inquiry will then be a committal to High Court. The notes are then prepared and sent to the DPP that considers what to indict. Then the indictment is prepared and filed in High Court, and at that time you're brought to High Court and stand in line and wait your trial.
Right.
My experience from my matters, it tends to be at least 8 years.
Between charge
and indictment. It's difficult to say how long you would take for your trial to start. And as controversial as it sounds, one of my themes of my report was Section 35, in that, look, if you haven't had your case started in 10 years...
Section 34. Right.
I've renumbered it. I've added a number.
Right.
If that, in Section 34, we're not dismissing your matter. If you haven't had your matter, if you haven't gotten... I've been the Inspector of Prisons for 5 years, having been appointed in December 2010. And forgive me, member. And if you haven't gotten your house in order in 10 years, perhaps you should consider bail. And that is not dismissing your matter.
Bail for murder?
A discretionary bail in all matters, which would include murder in certain circumstances. The learned DC of legal aid suggests a categorization of murder. And I did speak to a judge from a different jurisdiction that says, even in indictable offenses, all matters, if you don't have your house in order in 6 months, you are given bail. In terms of the breakdown, your preliminary inquiry might last 3 years.
2-3 years. Yes.
2-3 years. And then Chief Justice McNichol's days, it was about Chief Magistrate, I apologize. The Chief Justice of the Magistrate Court.
Right.
It was about 6 to 8 months.
And now it's 2 to 3 years.
2 to 3 years,
Okay.
and that is because, forgive me, Madam Chair, if I've gone beyond my remit. That was because they've changed the remand period from 10 to 28 days. So now you have 12 hearings in 1 year as opposed to about 50 hearings.
Right.
And the paper committal procedure has caused more delay than speeding it up.
Agreed.
Then you have another 3 years.
Mr. Khan, I just want to stick a pin,
Yes.
as one of my friends keeps saying, and ask you this. As Inspector of Prisons, is there anything within the prison system which can be changed and have the result of accelerating the process of criminal cases?
No.
So there's absolutely nothing the prison can do to accelerate the process.
I don't think so. No. Must be no.
Nothing that I have thought of for the last 5 years.
Madam Chair,
Yeah, sure.
through you, Madam Chair, to Mr. Khan. Mr. Khan, how long have you been Inspector of Prisons?
Forgive me, I was appointed in December 2010. I have since been reappointed 3 times, my current tenure to end in June of this year.
Okay. Mr. Khan, over the last 5 years, have you seen any changes in the prison system? Are you aware of any reduction, let's say, in the remand yard, how the system was dealt with over the last 5 years to reduce the backlog of cases? You're the Inspector of Prisons for 5 years. Tell us what transpired over the 5 years and how, because we are hearing a lot this morning. We're hearing all the ills this morning, but you have been there for the past 5 years. What is your input? Because you have seen the system at work. what has happened over the last 5 years? Has there been any improvement?
No. We have degraded further and further. When prison hits rock bottom, we start digging to get much lower, and it's become a bottomless pit. The prison population is a subset of the larger society, and forgive me for saying the larger society seems to be also digging a pit, and the dregs at the pit are being thrown in our pit, and our pit just keeps.
I'm sorry, I'm losing you, Mr. Khan. Perhaps
Madam Chair,
perhaps
you're
speaking too softly, or maybe you have other things on your mind. But I see that both Mr. Rambarat and Mr. Ramada have questions.
Very much, Chair. I find it a bit troubling, Mr. Khan, to suggest that there's been no improvement. You might very well be aware of the infrastructural work that have been engaged for some time now, and I thought today you might have been able to assist this committee and the nation widely as to improvements in the conditions at Remand Yard, and equally, and I speak now as a former Minister of Justice for a short period of time, of course, in relation to the opening up of the maximum security to take away a lot of the pressures of the Remand Yard, and also for the institution, I do not know how far it's gone, for the building of a 1,500-bed institution for pre-detention, pre-prison, if you may want to call that. Are you in any position to help us? Because to suggest that nothing has happened in the last 5 years really is not an accurate statement. Efforts had been made, whether they borne fruit at this point in time. And I referred to my earlier statement in relation to some of the legislative changes, and I congratulate you on your efforts too, and the contributions to the new prison rules, and if you could help us with those, so that we have a clearer picture of the tremendous amount of effort that has been put. Whether it has borne fruit up to this time is another issue, but that the efforts have been made and work, I'm sure, will be in progress. Could you help us with that?
Yes. Madam Chair, before Mr. Khan answers, my colleague, Mr. MP Ramada, I get a feeling as if you want to put words in the mouth of Mr. Khan. No, let me finish. Let me finish. I see Mr. Khan as a very credible person, very competent person. And I am sure Mr. Khan has been there for 5 years. He has been renewed 3 times over the last 5 years by the previous government. And certainly, I think that he is quite, I listened to a very articulate young man, seems to know exactly what he's talking about. So why you want to put words? He's speaking the truth. I want to jump his.
Could we just have some order, please? I think it was a straightforward question. And Mr. Khan, if you could answer it succinctly.
Yes. Contextually, I was not saying that nothing has been done. In response to Ms. McDonald's question, I interpreted the question as, has anything been done to alleviate delay? I hope that in context of us saying, I was saying no. In terms of development of the infrastructure, yes, the last administration, or within the last 5 years, which is documented by the Commissioner's letter of February 19th, about the infrastructure investment, the Eastern Correction Facility, the investment into the maximum security prison infrastructure, allowing for more cells to be used. And within that, and I did not mean to say nothing has been done, I was referring to nothing has been done nor can be done on the prison side to alleviate delay.
Yes, Mr. Khan, could you just help me with this? There would be persons in the detention center who would have matters before the courts. Are you responsible for those persons, or which group or authority or body is responsible?
That does fall under the Commissioner of Prison, and a liberal interpretation of my powers, it would fall under my remit as well. I understand, and if I could expand, that facility is being used to acclimatize inmates when they have 6 months to run out. That is my understanding at this point. I'm not sure whether that has been changed.
And where does your understanding based on?
Based on communication with the Commissioner. There have been some shifts in the last year
I
about
see.
separation.
So you can provide us with information in writing, let's say, perhaps with respect to the population of the detention center and how many persons are on remand there?
Yes, I can and I will.
And we'll appreciate that. Before Mr. Ramadar continues, I believe Mr. Rambarat had a question that he wished to ask.
Mr. Khan, I have a combination of questions and comments, and I'll make 4 points. The first is that I appreciate you drawing the distinction between prison and remand yard. I, of course, am a full-blooded solicitor. My knowledge of criminal law is purely academic. So I appreciated that difference. I think it's one of the things that I'll take with me through this discussion, because you drew a very important distinction and you drew an important point. You made an important point on the role of the judiciary in relation to remand yard. Now, I disagree with you based on my previous question on legal aid and prison. I disagree with you on, I believe that the prison has a role in this issue of the criminal case flow management. And we have to be very careful that this examination is not on prison and prison conditions. This is an examination of criminal case flow management. And I stick to my view that the prison plays an important relationship between the prisoner, including and the people on remand yard, the court, the access to justice, and the relationship between those persons and the judiciary. And I based on my previous question, formed the view before that access to justice within the prisons is an important part of the case flow management process. Third point I'll make in reference to my friend Mr. Ramadar, I don't believe that infrastructure plays an important role in the question before us. And the issues are more systemic than infrastructure. And I compare it to saying that the construction of hospitals will not improve healthcare. The construction of hospitals demonstrate a problem with healthcare, a systemic issue with healthcare. And I use the same reference to the prison. But I close on this point, and it's really for the benefit of the law students who are here, the law school students. The issue of legal aid has been a vexing one for a long time. Every report from legal aid would have said, we have fewer attorneys than we need. And legal aid was not attractive for attorneys in private practice. But I wondered whether you think, and this is a combination of your experience at the law school and your combination of your experience as criminal attorney and inspector of prisons, whether it was time for the Law Association to examine granting a limited right of audience for students at the law school, perhaps in their second year, to represent criminal defendants under the supervision of a more experienced attorney, in particular in rural courts. Now, I know the law allows people to be represented by a friend, but I thought that maybe it is a way in which we can supplement what is available through legal aid. I know the law school has its own legal aid, and maybe we should try to carve out a rule for these students, because we recognize that in our system, law students go through 5 years of training to get a full right of audience. And in other jurisdictions, that happens after 2 years, in some cases 3 years. And in the law schools, we have a student body that includes some far more experienced people than we would have had when I was in law school decades ago. So I just want you to consider that, and I'm just sticking to that point of access to justice and the relationship between that and criminal case flow management.
Yes, Mr. I know that we are all looking at the clock, but there are just a few things that I was hoping we could round off with. And Mr. Ambarat's suggestion sounds interesting, but I would imagine there are serious ethical considerations which would flow from the implementation of that kind of program. And if the Law Association is asked to make a contribution, perhaps they can express their view on that. But in terms of identifying persons who may be moved out of the remand section of the prison and have their matters dealt with more expeditiously, let's say in terms of identifying a group, is there any process by which, let us say, persons who have mental health issues and who are on remand, can they be identified by the prison authorities and managed, in a sense, to ensure that they are evaluated so that their psychiatric reports are brought before the courts? The courts know that you are dealing with a mentally ill person, and thereby the courts might be might give priority to such cases. Is there any possibility that something like that can occur?
Madam Chair, yes. They do. They can and they do identify those with mental health issues. As a matter of resources, there are, I believe, 2 psychologists and 1 psychiatrist at Service Prison, which would include 4,000 inmates and the prison officers as well that do have mental health issues at times. I don't mean to be that, but in that environment.
Yes.
To carry out evaluations may be difficult because also the forensic psychologists and psychiatrists in Trinidad are limited. In my first prison report, there was an opinion of Dr. Ghani that said the mental illness within the prison is substantially higher than out in the wider population. And he did say the wider population in Trinidad generally does have a higher percentage than other jurisdictions. So, but we can and we do identify those. To treat them would be another issue.
I see.
Madam Chair, through you.
Yes.
Mr. Khan, you are a practicing attorney. It is obvious that the delays have gotten much worse than it was 10, 15 years ago. Do you know that there are only 6 courtrooms in the Port of Spain Assizes and 4 in San Fernando, so that and only one matter can be heard in one court at a time. Do you agree that trials take much longer from start to finish when the accused is actually arraigned up to the time of the verdict? Do you agree that trials take much longer now than they did years ago? And if you do agree, can you give us some indication as to why?
Yes. To have a trial going on for 2 years is unacceptable.
That's not the question, but
Trials take longer because criminal principles have expanded to perhaps 10 legal issues that arise in a trial to about 30 issues. There are more applications in court for legal issues. There are cross-examiners, defense counsel that are not reined in by the judge and engage in protracted cross-examination. There are unnecessary adjournments to prepare written submissions. There's a decision by trial judges to prepare written judgments or rulings when they ought to exercise their discretion and give an oral ruling. There is not case management or in the civil jurisdiction where you front load the matter, meaning all the work you do is before the matter starts. You agree to what witnesses, you don't have to cross-examine every witness. Those are my suggestions.
Yes. My Vice Chair has a quick question before we round up.
Oh, sorry. Returning to the question of the conditions, of the mental conditions of the remanded inmates. there's a view that some sort of parallel incentive for good conduct for them is something that would perhaps help with the despair that they face, because currently there is no such incentive for those persons who behave well for that to be taken into account perhaps when they're actually sentenced. Is this something that you agree with? And any other suggestions along those lines?
Yes. In terms of convicted inmates, there is currently what is called a third discount of your sentence. It is for good behavior, to encourage good behavior. Because of accounting proceedings or management, you are often given that discount as of right, and it is withdrawn from you when you behave badly, as opposed to you have an incentive not to behave badly, as opposed to an incentive to behave well. And there is or ought to be put in place the parole board and encourage and reward prisoners for their good behavior, holding out the reward of an earlier release.
Yes, Mr. Ramada.
Thank you very much. Now, could you very briefly tell us, in terms of the improvement of communication for the use of telephones, legitimate use of telephones under controlled circumstances by inmates to family, friends, and even lawyers? 2, what is the status of the video conferencing, the infrastructural development for which, of course, will unburden the courts to actually deal with cases? And then you said something most troubling. The expansion of the remand period from 10 to 28 days was intended to prevent the unnecessary transport of prisoners to and fro when their cases could not go forward. I'm hearing now that that is used as a mandatory period, as a thing from a maximum period, when cases could be adjourned for any time within a 20-day period.
Yes. In regard to the first, there was tenders to install telephones within every hallway, within every section of the prison, which is manned by one prison officer, and therefore to facilitate that. There was, under the previous Minister of Justice, when there was a Ministry of Justice, a system to jam all the illegitimate phone calls, and therefore siphon it only to legitimate phone calls. In response to your 28 days, it was passed with the idea that at the beginning of the case, nothing would start, so you would take the 28 days longer to alleviate the transport. However, when a matter started, it ought to go from day to day, which the Chief Justice of the Magistrate Court ought to do. They used to force your hand, that is McNichols, to force your hand to go on the matter from day to day to day to day. But it is being used 28 days, 28 days, 28 days, and that is causing delay. The 10 days, it was to alleviate the concern, and it is not being exercised in that manner. It is causing delays.
We have a question from Mr. Mitchell.
Video conferencing facilities.
I apologize. The video conferencing was set up in a pilot project. I know there was it was run, the current Chief Magistrate, I believe, and subject to correction, had a pilot run and those kind of things about implementation. I cannot say at what stage that is and whether the pilot project was successful, but that is a very important and useful way to assist the prison system and the judiciary.
Sure. Mr. Mitchell?
Yeah. Notwithstanding the infrastructural improvements, the planned infrastructural improvements, can you give us an indication as to what improvements to the system of managing the consequences of delays in terms of the violence, any gang problems, that sort of thing?
The present commissioner is doing everything he can with the issue of separation and segregation because you have an influx of higher profile accused and that are there for longer periods. And it is extremely difficult, one, when they come into prison to ascertain their loyalty to what other inmates, I'm saying that loosely and I hope the committee understands, to separate them, not to put them in the same cell, and it's becoming increasingly difficult. What I was trying to say about digging the hole is that as society as a large gets more violent, you're taking the worst violent, most violent people and putting them in prison. And prison is getting more hostile, more heated, and desegregation is an issue, but there are many, many efforts. As Madam Chair alluded to, the Eastern Correction Facility is being used to put some here, MSP here, and just to move them around, but it's difficult to know what an accused person's affiliation is. And you have accused persons or defendants charged with minor matters that are being commingled with those charged with more serious offenses, which is against the prison rules, because they would increase their exposure to criminality. I hope that addresses your concern.
Yes.
One other question. Is there an information-based management system at the prison, or is it just done by paper records?
I believe it's being digitized. The warrant section is a large body of statistics that could, I believe, inform this committee as best to the figures. When you come in, you have your what offense you're charged with, what area, your remand. You would have your date of committal or your date of entry into your date of indictment, and it does go along to help the statistics. But no matter what the statistics show, is that the delay is unacceptable.
Okay. I believe these are the questions which the committee has for you, Mr. Khan. Thank you very much for attending. Thanks to the legal aid officials who are here, and we are hoping that we will be able to ask you some questions on the next occasion, which is due to be the 18th of March, if that is convenient to you. If it is not convenient, then perhaps we can schedule another session. But please feel free to communicate with Mr. Ogilvie to let him know what best suits you. So, Mr. Khan, thank you. You've been very helpful.
Much obliged.
And the meeting is now adjourned.